Welcome back, folks, and now on to Chapter 4 and Civil Liberties. Okay, here are learning outcomes for the week. We'll define civil liberties, we'll identify rights included in the Constitution, describe the Bill of Rights, and explain how it came to be applied to state governments. We'll identify how the First Amendment provides for freedom of religion and freedom of speech. We'll analyze the legal basis for the right to privacy and explain how the principles has been applied. We'll explain the rights of the accused and describe how they've changed over time. And we'll analyze how civil liberties are often in tension with safety and order and provide examples. Let's take a minute here and define civil liberties and civil rights. And there's often some confusion about the differences between the two. Civil liberties are really about what the government can't do. They involve restraining government. Civil rights are what the government must do. It is an action the government must take to protect the rights of individuals. The 14th Amendment of the Constitution is one of three post-Civil War amendments to the Constitution. And the 14th Amendment begins the process of applying the Bill of Rights to all levels of government, to the states, to local government. This is referred to as the incorporation theory. And the 14th Amendment requires equal protection under the law. All right, we'll jump into the First Amendment, which is a biggie. And freedom of religion, two clauses in the First Amendment that relate to freedom of religion. The Establishment Clause, which says essentially that the federal government and then later all governments cannot set up a church, and free exercise, that is, that people should be able to freely exercise their religious faith. The Establishment Clause is often known as the separation of church and state clause, or what Jefferson referred to as building a wall between church and state. But that has always oversimplified the relationship between religion and government in the United States. There's actually, since the early days of the Republic, there has always been a relationship, some relationship, between church and state. So the question is not whether or not one will exist at all, but what should that relationship be? So as you look over the reading, look at some of the key issues that are discussed. The role of school vouchers, prayer in schools, teaching evolution or intelligent design, whether or not religious displays should be put on public property. In general, the Supreme Court has been critical, obviously, about supporting one religion over another, establishing one over another, but has recognized that there are situations, secular, non-religious reasons for a relationship between church and state. And in many cases, religious organizations will carry out a non-religious function. That could be a charity, that could be a school. And many private schools in the United States, for example, are Catholic schools. And in addition to religious training, they're also carrying out a secular goal with regard to education. Where the Supreme Court has taken a harder line is where there isn't a non-religious reason for that relationship between church and state, like prayer in schools, teaching evolution, or intelligent design. The Supreme Court has been much more critical of those areas because they do not pass the Lemon test. Make sure that you read and understand the Lemon test and how the Supreme Court assesses whether or not a relationship between government and religious organizations are permissible. Likewise, with regard to religious displays on public property. The second clause in the First Amendment that relates to freedom of religion is the Free Exercise Clause, which says that religious practice cannot be prohibited or restricted by the government. Now, we know from our conversation, our discussion so far, that all rights have limits, and so does the free exercise rights that we have for religious practice. And I think we can probably in our head think of certain religious practices that may be prohibited because of broader societal needs. An example would be those people who have religious views that discourage the use of vaccines. Government may say, hey, there's an overwhelming public need to get folks vaccinated to prevent the spread of infectious disease. That would be an example. We've also seen situations where some religious practices are deemed unlawful, like plural marriage, marrying multiple people as an expression of your religious faith. And the Supreme Court has ruled that plural marriages create destabilizing forces within communities, and it is within the rights of governments to limit that practice. Okay, sticking with the First Amendment, we'll move on to freedom of speech, freedom of expression. What the framers of the Constitution and the Bill of Rights are really concerned about was prior restraint initially. They didn't want government, particularly this new federal government, to have the ability to restrain speech, to constrain speech, to restrict speech before it actually was expressed. So that's this term, prior restraint. They didn't want prior restraint. Over American history, the Supreme Court has broadened protections for speech in many cases, but not all forms of speech equally. Some of the forms of speech that the Supreme Court has specifically protected include political speech, which in many cases includes symbolic speech, artistic speech, commercial speech would also be a form that's protected. And the Supreme Court does not view all speech equally. So political speech and speech that has to do with the central debate within our democracy, that's going to be much higher than, say, commercial speech, which would be about maybe selling a product, it would be about like selling Cheerios. And so the ability of government to restrain political speech is much more limited than the ability of government to regulate commercial speech. It's for that reason, when you see those pharmaceutical ads and half the ad talks about all the terrible things that are going to happen to you, maybe if you take that drug, those are much more regulated forms of speech than you would see in perhaps a political ad, which in many cases are, contain falsehoods and perhaps even outright lies. But that form of speech is much more protected from government action. Well, I've said it before, but all civil liberties have limits, and the freedom of expression is no exception. The Supreme Court has allowed government restrictions in certain areas when there is a clear and present danger, a specific bad outcome that the government has a duty to prevent, when an action could create imminent lawlessness. And this is the power of the Supreme Court to determine when speech has gone into one of these areas that will allow for restriction. Freedom of speech does not allow you to go into a crowded movie theater and scream fire to create chaos. That is not the intent of speech freedom. Like I said, the court has ruled over time that the most important speech that ought to be protected is political speech, is the speech that's necessary to continue our democracy. Some examples of speech that fall out of First Amendment protection: obscenity. Now, this is an ongoing area of controversy because one person's example of obscenity is another person's high art. So this is an area that continues to be debated by the courts. Slander or libel. Slander is a false and defamatory statement that's stated out loud. Libel is a false and defamatory statement that is in print. But that is a form of speech that is not protected. Now, we'll get into that, but when it comes to political speech, the courts are willing to give much more latitude when it comes to slander and libel, particularly when the speech is directed toward a public or a political figure. We'll talk about that in a little bit. Fighting words, threatening people, slurs that provoke violence, this isn't protected speech. And hate speech, a speech that any speech that is focused on attacking an individual's race, religion, or other characteristic, that is not protected speech. In all these areas, though, there's a great deal of debate as to whether or not something has crossed a threshold into hate speech or fighting words or slander or libel or obscenity. Moving on to freedom of the press, which is also a prominent component of the First Amendment. The Constitution places this very high right there in the First Amendment because a free press is essential in a functioning democracy. Otherwise, how would we have the information that we need to make democratic decisions? So the press has some protection from libel charges. It would be really hard to cover public figures if the press could be easily sued. Some people don't like that because it leads to a very aggressive press, and in some cases, the press depends on the fact that courts will make it very hard for public figures to go after them for negative press coverage. So, as an individual, as a private individual, you or I, if we were defamed in a news article, and that could be online, that could be on TV or whatever, and if it was inaccurate and if it led to some harm, as private individuals, we would be much more likely to be successful in suing a newspaper or a radio station or whatever than would a public figure. So the ability to sue for libel or to sue for slander has a lot to do with whether or not you're a public figure or not. The press is also protected from gag orders that if, say, a judge during a very high-profile trial said that the press couldn't report on this, it's in most cases the court system would overrule that. They would say that no, the press has a legitimate role here in reporting on this trial. Now, under some unusual circumstances, a gag order might be allowed, but they're exceptional. Now, an area of exceptions for freedom of the press has to do with radio and television. They have much more limited First Amendment protections. For example, they can be regulated for decency. What you see in broadcast TV or broadcast radio is going to be a lot different, right, than what you would see on cable TV, cable satellite radio or TV, or on the internet. And the courts have ruled that because radio waves transmit into our homes, whether we want them or not, that it is all right for government to regulate them at a higher level for certain standards. Also, frequencies need to be regulated. You can't have everybody broadcasting however they want, or our TVs wouldn't work, our radios wouldn't work. So government has a legitimate role in regulating who can broadcast on what frequency, for example. An ongoing controversy with regard to freedom of the press is, should press be allowed to publish information that was gathered illegally? Does it matter how information is obtained? So if somebody breaks the law like Edward Snowden did several years ago with the National Security Agency, spy agency, and releases information on how the government is gathering data on citizens, should the press be allowed to legally publish that information? The Supreme Court has ruled in most cases, unless there is a clear eminent national security need, that in most cases the press does have that protection. The other issue too is if the press has information from confidential sources that could be related to a crime that's been committed, should they have to turn over that information? Should they have to turn over their confidential sources to the authorities? It is for this reason, in many cases, you'll have members of the press that will be arrested for failing to turn over information that they know in order to protect their sources, because if a reporter doesn't do that, they're unlikely to get high quality confidential sources in the future. Right to assemble and petition the government, yet another liberty protected by the First Amendment. And this is the right to protest. And this is something that we've seen a great deal of, right, in Minnesota and across the country recently. So there exists a clear right to assemble, but like with any civil liberties, there are limitations on those rights. And so I want you to think about what those limitations are and whether or not they're justified. For example, if you have 20,000 people at the Capitol, you are going to need porta potties. You're going to need a place for folks to go to the bathroom. So there's going to be some reasons for the government to know in advance that that protest might occur. And so in many cases, there are processes for people to apply for a permit so that they can have a protest at the state capitol. And the Supreme Court has been okay with those regulations. But what the Supreme Court calls for is that all groups are treated equally. So whether it's the Ku Klux Klan or the Boy Scouts of America, the process is the same. Government cannot take a role in determining whether they like a particular group or not, as long as their behavior is lawful. Now, of course, if a group becomes violent or whatever, then that's not lawful behavior. The right to privacy is arguably the most controversial of civil liberties that are interpreted in the Constitution, in the Bill of Rights, and it's because there's no enumerated specific constitutional right to privacy. This is an interpretation by the Supreme Court. This was established in the Griswold v. Connecticut ruling, and this Supreme Court case was related to the fact that Connecticut had a law that banned use of contraceptives. Connecticut at that point was an extremely was a state that was very Catholic, and they had specific laws that made it all but impossible to access contraceptives. And essentially what the Supreme Court ruled here is that you have a zone of privacy in your life and that the government cannot involve itself with. And this is part of it. And that it in some ways is so basic that it doesn't have to be specifically addressed in the Constitution. Specifically, the Ninth Amendment deals with this, that says the Bill of Rights is not meant to be exhaustive with regard to individual civil liberties. The Griswold ruling creates a legal foundation for Roe v. Wade, which ruled that privacy rights protect some abortion rights. And it was never unlimited, but that the rights of the woman, to some extent, are in tension with the rights to the prospective child. And during the first trimester under Roe v. Wade, most of the rights are the woman exercises those rights as to whether or not they want to keep the pregnancy or not. Middle trimester, they're more in balance with the prospective child, and then the last trimester, they're much more on the side of the prospective child. But the Roe v. Wade sort of acknowledges that some right exists. Since Roe v. Wade, more conservative courts from the 1980s and the 2000s have taken a much more restrictive view of the rights outlined in Roe v. Wade. For example, they have permitted waiting periods for women who wish to seek an abortion, rules that state that abortions are not accessible if there's a fetal heartbeat. These sort of things have been accepted by more conservative courts. But more recent conservative U.S. Supreme Courts have never completely overruled Roe v. Wade. They've just limited it quite a bit. And so there are some states within the United States where it is essentially impossible to end a pregnancy by an abortion. For example, South Dakota would be one such state. Privacy rights is also related to whether or not the Constitution protects the ability for someone to seek a physician-assisted suicide if, for example, they're terminally ill. In this case, the Supreme Court has said that the Constitution doesn't include such a right, but it has also said that the Constitution doesn't prohibit it. And it's for that reason that some states, such as Oregon, allow for doctor-assisted suicide for terminally ill patients, but other states don't. It's important that you build an understanding of how the Constitution protects the rights of the accused, how the Bill of Rights protects the rights of the accused. And as you know, the Bill of Rights initially only applied to the federal government, but after the 14th Amendment, the Bill of Rights slowly and over time was applied to the states and all levels of government. So again, as you're considering your reading, take a look at the Fourth Amendment, how it relates to unreasonable or unwarranted search and seizure. Fifth Amendment, which deals with self-incrimination, double jeopardy, coerced confessions, prevents all those things. Sixth Amendment, which requires that people have access to legal counsel. And again, initially this was just for as a protection against the federal government, but now is applied to all levels of government. And the Eighth Amendment, which deals with bail and prohibits cruel and unusual punishment. Now, as you can see, when you start to deal with things like cruel and unusual punishment or reasonable bail, these are judgments, and ultimately the Supreme Court makes the judgment. So if you're wondering what they meant by that, well, they mean whatever the Supreme Court says they mean. Rights of the accused have changed over time. Rights of the accused today are vastly different than the rights of the accused were in the 1950s. They expanded a lot in the 1960s and 70s. They contracted a lot in the 1980s, 90s, 2000s. So this is a balancing act over American history, and there is a tension between overall societal order, safety, as we've discussed, and rights of individuals who are accused of a crime. Some of these rulings I'm sure you're very familiar with that limit police and prosecutors today. Miranda Rulings requires police to inform suspects of their rights. That the right to an attorney is applied to anybody who's accused of a crime, not just somebody who's accused of a federal crime. And also that any evidence that is gathered illegally cannot be used to convict. This is referred to as the Exclusionary Rule. Spend a little bit of time with each of those, making sure that you understand them. Obviously, those important Supreme Court decisions made it more difficult for the government to prosecute, and more recent Supreme Court decisions have moved in the other way, particularly during the 1990s and 2000s, that relaxed some of those rulings. And this is the balancing act. How do you accommodate the needs of government to operate a criminal justice system that is effective with the rights of the accused? Critical issue with regard to the rights of the accused is the death penalty. The United States is the only advanced democracy in the world that sentences people to death. We have a federal death penalty, and many American states have a death penalty. We also have the Eighth Amendment of the Constitution that prevents cruel and unusual punishment, and there have been certainly those people that wish to argue that the death penalty is in violation of that. The Supreme Court agreed, and during the 1970s, most state death penalty statutes were found to be unconstitutional because there was so little consistency across states on how the death penalty was carried out. In many cases, it led to a great deal of pain and suffering. However, more conservative Supreme Courts and revision at the state level has been accepted by the Supreme Court, and that newer laws that in many cases revolve around lethal injection, that these are not in violation. But this debate continues to continue today. And of course, whether or not the death penalty can be sentenced to those people who are minors at the time of their crime. The Supreme Court has ruled that it cannot, or people that are not mentally capable of understanding the severity of their crime. Those are both issues that have been before the Supreme Court. Okay, I'll skip past this. Okay, just to summarize here, freedom of religion includes both the free exercise of one's religious belief and limits the government from establishing or respecting a certain faith, the Establishment Clause. Freedom of speech is an expansive right in the United States, and one that is expanded over American speech. That includes political speech and symbolic speech, and to a lesser extent, artistic and commercial speech. Symbolic speech would be something like burning an American flag, something that is as controversial and offensive as that form of speech is to many Americans. As interpreted by the Supreme Court, that is speech that is protected by the Constitution, by the First Amendment. Freedom of press is also in there. Freedom of press is a specific example of freedom of speech, and Supreme Court, as well as the folks that drafted the Constitution, recognize that you cannot have a functioning democracy without a free and robust press. It's important to recognize that the Supreme Court interprets the Constitution, and people's rights are not limited to those that are specifically enumerated in the Constitution. We know that there are certain implied rights that we have, and one of which is the right to privacy. That includes reproductive rights and a limited right to end a pregnancy, for example. The Constitution also, and particularly the Bill of Rights, spends a great deal of time laying out the rights of the accused. But likewise, like with all the liberties that are discussed here, there are limitations, and those rights have changed over American history. And finally, your discussion questions for the week. This will also be posted in the weekly discussion area. Follow that grading rubric carefully so you can maximize your participation grade overall. As always, make sure to reach out to me during office hours or send me an email or post on D2L if you've got any questions or concerns. Have a great week.